Do we have a case number on the on Christopher Matson?
18-455.
All right. Reviewing this affidavit, the court will find that the defendant qualifies for the public defender's office. Making the appointment. The PD is appointed on that. This matter is for arraignment on charges of commercial burglary, which is a Class C felony, and assault in the third degree, a Class C misdemeanor. On those charges, how does he now plead?
Not guilty, Your Honor.
Plea of not guilty is noted. He's on the Division III docket of Judge Putman. I'm setting him for reappearance on October 25th in front of Judge Putman.
Your Honor, before he is excused, what does the court show that his bond is set at?
Let me look that up.
15,000, Your Honor.
Okay.
Your Honor, when I visited with him in jail yesterday, he has a residence in Baxter County, 73 Larson Trail in Mountain Home that he can live. That is with his sister, whose name is Janie Mites. Given the nature of the charges, I'm not 100% sure of his criminal history, but I would ask that his bond of $15,000 be substantially reduced.
Well, according to the facts stated in the affidavit, this case involves not only the entry into unauthorized entry into a business establishment, but holding the owner of that business at gunpoint. I think $15,000 is an appropriate bond, at least that amount. So I'm not going to reduce it. That'll be the order of the court.
Your Honor, he will be, I assume, brought over in front of Judge Putman next week.
Yes, that's what I'm directing.
Mr. Matson, Mr. Bailey can readdress bond with Judge Putman next week also.
Okay,
All right, you may be excused, sir.
thank you.
2018-449, State of Arkansas versus Brandy Withrow. The court is approving Ms. Withrow for representation by the Public Defender's Office. The charges against Ms. Withrow are damaging wires of telephone, cable, and electric companies, Class D felony, theft of property, a Class A misdemeanor, and theft of services, a Class A misdemeanor. On those charges, how does she now plead?
Not guilty to all charges, Your Honor.
Plea of not guilty is noted. Once again, her case is assigned to Judge Putman's docket. I'm setting her down to reappear on October 25th in front of Judge Putman. You may be excused. 2018-446, 2018-448, State of Arkansas versus Mac Davis. All right. The record to reflect the court is making the appointment of the Public Defender's Office to represent Mr. Davis on both cases. On the charges in the 2018-446, which are possession of controlled substance, a Class D felony, and in case 2018-448, the charges are theft of property, a D felony, and breaking or entering a D felony. On those two sets of charges, how does the defendant now plead?
Not guilty, Your Honor.
Plea of not guilty is noted in each of these cases. These cases are on this court's docket. The court is setting, pursuant to the new policy we're implementing with a limited number of reappearance dates. The court is setting the defendant down for trial during the week of May 20th of 2019. And he'll be ordered to reappear for the deadline date, or it can be a pretrial date of March 7th. In any case, it's the final date before the trial week, so he's ordered to reappear on March 7th of 2019 and May 20th and set for trial during the week of May 20th of 2019. Any other matters to come before the court?
Your Honor, there are not. I would tell Mr. Davis that when he and I met yesterday, we discussed some items and possible resolution, and I will tell Mr. Davis that we are not where we need to be at, Mr. Davis. He will understand that, Your Honor.
All right, you may be excused. (2018-436) State of Arkansas versus Nathaniel Campbell. All right. Court's making the appointment of the Public Defender's Office to represent Mr. Campbell. I have it down that was the primary purpose in his being here today. I don't see that. I think that there's already been arraignment in this matter.
That was my understanding also, Your Honor.
That's verified. I just don't want to have one go through. No, maybe not. This says plea and arraignment continued. So, before we go on, the charges in this case are theft of property, a Class D felony, and breaking or entering a Class D felony. On those charges, how does he now plead?
Not guilty, Your Honor.
Court's entering a scheduling order that sets Mr. Campbell's case for the trial during the week of May 19th, and I'm also setting it for reappearance on March 7th. That'll be the one and only date that's set for you to come back before the court before your trial date. Mr. Campbell, I'll advise you that if you get out on bond at any point, you need to understand that it's not your attorney's requirement that they come and find you. It's your responsibility, getting court-appointed attorney. It's your responsibility to get in touch and stay in touch with them, and I'm ordering you to do so. What that means is if you get out of jail, it's your requirement to contact the Public Defender's Office, set up an appointment, and get in to see Mr. Cooper as quickly as possible after you get out of jail. If I find out that March 7th, when your court appearance date is, you've not been in to see him, you can expect to be found in contempt of court and jailed at that point for contempt of court, because I'm ordering you to do that. So don't fail to get in touch with your attorney if you do make bond and get out of jail. Court has appointed the Public Defender's Office to represent Mr. Campbell and entered his plea of not guilty, and he's set now for trial by scheduling order. You may be excused.
Sir,
Yes.
would I be eligible to do a bond reduction? I've been on the bond for $25,000 for those charges. And I'd be able to make some bond, but that's a little much for me right now. They lifted my parole hold and everything else has been lifted. It's just, I could make some bond, just not $25,000.
What says the state on the request for a bond reduction?
Your Honor, since there's been, the hole's been lifted on here, Your Honor, the state would not be objectionable that bond being reduced to $15,000.
All right. That'll be where the bond will be set, $15,000.
Thank you.
You may be excused. Court will call 2018-182, State of Arkansas versus Ronald Culver. Gentlemen, this case is down for trial next week. What's the status of this case?
You know, I visited Mr. Culver yesterday at the jail, and there is a plea offer in the case. At this time, he has not accepted that. I've talked to Mr. Etheridge about this case this morning, and there's no objection from the state for me to have some additional time to discuss this case with Mr. Culver. I will say that, Your Honor, and I'll say this to Mr. Etheridge also, that's Certainly not a guarantee to the court that we're going to have a resolution, but I would like to have some additional time to discuss the matter with him.
I'm continuing the trial of this matter from next week to January 7th of 2019. I'm setting it down for November 15th for him to appear. He either pleads by that date or the matter will be on for trial the week of January 7th.
Your Honor, the state wants Mr. Culver to be aware that if he does not plead that day, that we will try this case. The state also wants Mr. Culver to be aware, and I'm sure he is, there's also a pending revocation in Washington County that we're going to notify Washington County today that he has not agreed to our plea offer, and so they may move forward on the revocation against him also.
All right? Very well. Mr. Culver, that's the status of the case. Is your next court appearance will be November 15th, and you're set for trial. That continuance is an excluded period. Will be down you're down for trial the week of January 7th. You may be excused.
Yes, Your Honor.
2017-186, State of Arkansas versus Connie Williams. Ms. Williams, you're appearing at this time. And before we do anything else, I'm reviewing a petition for the appointment of the Public Defender's Office. Have you filled this out and signed it?
Yes, sir.
Court is making the appointment of the Public Defender's Office to represent Ms. Williams. Ms. Williams, it's the court's understanding that you're appearing before the court at this time, having discussed a possible resolution of your case with your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Okay. I need you to answer out loud so the
Yes,
court
sir.
reporter can hear your answers. I can see a head nod and know what you're trying to say, but you have to say it out loud so the court reporter can hear it, please. Do you understand that your case is being charges against you are being amended from a revocation charge to one of contempt of court? Do you
Yes, sir.
understand that?
Yes, sir.
And have you discussed with your attorney the terms of the agreement that's being entered into today?
Yes, sir.
All right. So you know that by changing your plea on the agreement, you would be eligible to accept an agreement with an 89 days in jail would be what the penalty would be, with credit for time that you've already served.
Yes, sir.
You understand that's the agreement?
Yes, sir.
Have you discussed this with Mr. Cooper?
Yes, sir.
And are you satisfied with the advice and the representation Mr. Cooper's given you?
Yes, sir.
Is this a plea agreement that you wish to accept at this time?
Yes, sir.
All right. Ms. Williams, the original revocation petition filed against you in, I believe, January of 2017 alleged that you had a new law violation in Jefferson County, Missouri, that you failed to report as instructed back in failed to report to your probation officer here in Baxter County that you had unpaid fines and that you were out of compliance and your whereabouts were unknown. I think that's what was charged in the January of 2018. I think I said 17 a minute ago. It's 2018. And those were the allegations in the original petition. When we amend a charge to contempt, we're alleging in contempt is that you're in violation of you're in contempt of a judge's court order by being in violation of that order. The order we're now accusing you of violating is that same probation order that required you to comply with certain terms and conditions. Do you understand that? You understand what I'm saying?
What the court is asking you, the court has read off the allegations in the petition. On at least one of those allegations, are you admitting that you violated that, as you had told me in the hallway?
Yes.
Okay. So you understand that's what the allegations have been changed to, is that, you know, you were originally charged with revocation for violating those terms and conditions. We've changed it to contempt of court for violating a court order, but it's the same court order, so it's the allegations against you as you violated that court order. That's going to be what the finding the court has to make in terms of contempt of court. I just want you to make sure you understand that.
Yep.
All right. Are you entering this, you're entering this plea understanding the nature of the charges against you and the full range of penalties you're facing?
Yes.
You're entering this plea understanding that you are, by pleading guilty, you're pleading, how do you plead today? I guess I should ask that on the contempt charge.
True.
Okay. You're entering this plea of true pursuant to, by entering this plea of true, you give up certain rights you have. In other words, if you had pled not true to this, you would be entitled to a hearing. It isn't a jury trial, but it's a hearing in front of the court in which you have certain due process rights. One of your rights would be that you have a right to be represented and assisted by an attorney throughout the process. One of the rights is that you have a right to confront witnesses who would appear and testify against you at that hearing, and after the hearing you'd be entitled to appeal. At the hearing, the state would have the burden of proving that you were in violation of a court order. And so it's basically, those are due process rights you have: the right to the hearing, the right to attorney, the right to confront witnesses, and the right to appeal. All of those are rights that you have that you give up by pleading true. Do you understand that?
Yes, sir.
And understanding what rights you're giving up, are you still willing to plead true?
Yes, sir.
Are you entering this plea of true freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering
No, sir.
this plea? All right. In entering this plea of true, are you admitting that back in the latter part of September, October, and December of 2017 that you had in fact failed to report several times and had in fact ceased reporting to your probation officer?
Yes, sir.
Based on that statement, the court finds the defendant has freely and voluntarily entered a plea to true to contempt, done so after consulting an attorney, and has admitted the nature of her actions that violate the court's order. On that basis, the court at this point accepts her plea of true, finds her to be in contempt of court, and will sentence her in accordance with the agreement to 89 days in the Baxter County Detention Center. She'll be credited with time already served. You may be excused at this time.
Thank you.
2018-114, State of Arkansas versus Benjamin Brabin. Is this case down for trial next week?
Your Honor, Mr. Braben was supposed
Failed to appear, I
Yes.
understand.
and he has been in jail for approximately 2 to 3 weeks. The main thing I was wishing to accomplish today was to let the court know and let Mr. Etheridge know that his bondsman has said that he will stay on his bond, and I would like to get him released. And if he's released, then he needs to be aware that he needs to get in and see me, and we can get, if he wants a trial, we can certainly do that, but we need to be able to see him so we can get prepared for that trial.
Is that your request for a trial?
Yes, sir.
Well, you didn't help us get that done by failing
No.
to appear.
I apologize about that.
Well, you're gonna be set, once again, you're gonna be set for, the trial the week of, the trial week will be moved to, because of your non-appearances, it'll be an excluded period, will be moved to that January 7th trial date. That'll be your date for trial.
Okay.
I'm putting you down for reappearance on, November 15th. If there's any matters before trial to be taken up, we'll take them up on November 15th. If it's not pled out on November 15th, it will be going to trial during the week of January 7th.
We understand, Your Honor.
Okay.
Your Honor, upon receipt of the letter from Ron as bondsman, can he be released from jail?
What says the state on the bond issue? I mean, this is a person who didn't appear.
You know, the state objects to that for that very reason. He had a bond, he failed to appear, which has made us have to continue a case because of that and take up another trial date. And so the state would object to that, him be given another bond based on that behavior, Your Honor.
Your Honor, it is much.
When was he reapprehended?
Since October the 2nd, Your Honor.
Your Honor, if being in our jail for 15 days does not get the attention of Mr. Braben, then nothing is going to. He has admitted to the court that he made a mistake.
Please.
I'm trying to find the specific amount of the bond he was out on.
$10,000, Your Honor.
I'm gonna reset the bond to $20,000. I'm concerned if he bonds out, he will not appear, as he didn't on that. Maybe at this point, I have no problem if the bondsman wants to give him credit for the $10,000, but he's gonna have to come up with a $20,000 bond on this time to be released. I mean, I understand he's apologized, but that doesn't alter the fact that we're having to, we're having to move our trial dates and reschedule this whole thing. So I'm not going to encourage people just not to show up to court and think they can come in and apologize and all is forgiven. Doesn't work that way. When you're ordered to appear in court, you appear in court. I don't know what your excuse was or why you would say you didn't, but
I thought we were
the
set
bond
for
now
trial.
will be $20,000. You'll have to negotiate with your bondsman to see if he'll stay on that. All right. You may be excused.